Good morning, Your Honor, and may it please the Court. If, as this Court recently observed, adversity builds character, my client has had a great opportunity to build a very strong one. Strong enough to gain the unanimous support of the Character Committee and the Board of Law Examiners, and strong enough to merit what I believe is the unanimous support of this Court. Not because his life has been perfect, but because he's overcome a history that has been far from it. I will argue that this Court should indeed admit this applicant because he has been honest throughout the process and because he has grown beyond his prior problems and has, in the vernacular of this Court, been rehabilitated. Character, as this Court observed in Knight, is largely associated with credibility. It is not something that you can simply infer from credentials, achievements, or past missteps. There's not a really good way to define it. But what we do look for is good character. Not perfect character, not a spotless record. And this Court recognizes that people change, they mature, they settle down, they get focused, they grow. And that is what this record shows for this applicant. He has never lied, concealed, or embellished, though he has a history that might even set a Guinness record for traffic offenses in some ways.
Well, yes, there are the traffic offenses. Were there omissions in one or more applications, application to law school, application for admission to the bar?
No, and there's no evidence of that. As to law school, one of the problems is that my client attended the Charlotte School of Law, no longer in operation, and they also have not maintained their records very well, so we couldn't even obtain the law school application. But as far as the University of Baltimore is concerned, there was an application submitted to the University of Baltimore. The University of Baltimore wrote a letter back indicating that he did indeed disclose these various offenses. So there's no indication of a law school problem. Now, would I say that the application to the bar was perfect? No, it wasn't perfect. For example, the wrong box was checked as far as do you have any civil lawsuits. There were, but he actually did disclose many of them. It just essentially checked the wrong box in one area, but disclosed it nonetheless. So perfection in terms of filling out an application isn't what this Court is looking for, I know. That may in some ways be relevant to fitness, but it's not something we would punish with the destruction of someone's career and dream. It is, in many cases, something that ought to be a learning opportunity for someone young and starting out in this profession. As many of you may know, I used to be a law professor. It was a wonderful job, and I had many a student come in to review their papers, and some would make inadvertent omissions in those papers, and I'd call them out on it, and we'd use it as a learning experience. It wasn't a situation where there was an intent to fabricate or conceal. And certainly in this application, if anyone wanted to fabricate or conceal, there would be plenty of opportunities for that, but that's not what happened. What we have are a litany of offenses. But what I also think the application shows is that if you were to graph it out on a chart, you would see earlier in life a lot of dots, but very few in recent years. An example would be the traffic violations. Here's a man who has literally slowed down in recent years. He hasn't had a moving violation in 13 years. Right? This is one indication of growth, of maturity, certainly.
Refresh my recollection on the nature of the violations. Were they speeding, driving on a suspended license? Maybe one followed the other? I don't know. Could you help us with that?
Most of them were speeding. There were 3 instances of driving on either a suspended or what they call a refused license, and that dealt with delinquencies in child support, which I want to address. And there was one DUI for which he got probation before judgment. That was back in 2006, never repeated again. So
was that the most recent of the driving offenses, the 2006? Or
no, The most recent offense was about 13 years ago, and that would have been in, it would have been 2006, actually. And I think that would have been one of the most recent, yes. I think there may have been an improper lane change or something of that sort, but nothing that we would ever be proud of, but it wouldn't put him on the FBI's 10 most wanted list either. And in fact, none of the infractions in his past deal with fraud, deceit, false statement, the kinds of things that this court would look at and say, well, we don't know about this person.
Well, Mr. Kramer, there are the assault aspects, and I understand that we may not be talking about convictions, but there has been an admission that he did engage in assaultive behavior in personal relationships.
That's correct.
And one of the things that I'm concerned about in reviewing the application is that those aspects reflect certain issues with mental health concerns, in the sense that assaultive behavior can be seen as an anger management issue. So I'm interested in, when you're talking about growth, how he reflected his acceptance that he needed support in anger management in what I might call mental health concerns.
Well, you do see in the record that in 2013, he felt, based on anxiety and depression, that he would discuss that with his primary care physician and has gone on antidepressants and anti-anxiety medication, which actually he found has been helpful. So that's one way of addressing it. There haven't been anger management classes and things of that kind, but you also don't see anything, and the last one was 7 years ago, all right? Not ancient history, but enough time has passed that if we're talking about a person who was really such a threat, you might see something more recent than that. And you don't. I think what's particularly important is, here's a person who could have said, listen, I never laid a hand on anybody. That's not what he said. He owned up to it. Now, we're not talking about a barroom brawl here, certainly. You're not going to get any argument from me that any degree of physical contact is improper. No question. And would indicate a significant problem with character. But the question really becomes, what was the intensity of that? And I don't think we should really speculate as to, well, maybe he has mental health problems.
I'm not speculating here, sir. Now, after a period of time, I can tell you that after a bit of training with people who certainly have a dog in the fight, it does, assaultive behavior in a domestic relations context does show mental health issues. And you've reflected that with respect to how he's viewed, his past. I mean, these are not independent. My concern only is about repetitive behavior. And so I'm asking, basically, how is he dealing with the chance that this could recur?
Well, I think one of the best persons to talk about that, Judge Battaglia, is Kathy Starks, who testified at the Character Committee and said, this man is a gentleman. He has never lifted a hand to me. He's a good guy. Ironically, that same statement came out of Crystal Ramsey, who was the subject of, I believe, 4 of the 6 allegations.
And this goes back how far in time? We saw the papers that you just submitted. I don't know if everyone had an opportunity.
Crystal Ramsey is one, is the subject of a few of the assault charges that were brought. And
on the most recent that you submitted to us, is it she who signed an affidavit, or am I misremembering?
Well, let's see. Crystal Ramsey was involved in September 1, 2009, September 28, 2010, and August 3rd, 2011.
Okay. Well, this is another individual altogether.
Well, Stephanie Figueroa is who you might be referring to, and that would be...
No, I was thinking of Ms. Meekins, who
Oh, yes. And we disclosed that yesterday because we found something that we didn't see before, so we wanted to disclose it. I actually spoke with Ms. Meekins yesterday, and she was effusive in her praise of the applicant.
Now, she's the mother of one of the
That's
applicants.
correct, with Kennedy. And she says, hey, I consider him a friend. He's been a wonderful co-parent with me. She didn't even remember it. She wouldn't deny that, because the court record shows that there is a protective order. But she had no recollection of that, and she was pretty adamant that he had never laid a hand on her. And she said, look, we were young, we were under stress, we were new parents, and I may have done something in anger, but I can tell you that this man has never laid a hand on me. And my client has told me that as well. All right? He's admitted otherwise in other situations, but not in that situation. And she seems to confirm that, and she was kind enough to provide an affidavit, which I've also shared with this court. So you're talking about people who have indeed vouched for him that you might expect would not. There's only one exception, that's Stephanie Figueroa. And the character committee tried to weigh credibility there and found that her position, well, her initial position, which she then retracted on a rather lengthy and inflammatory voicemail, was probably lacking in credibility. They tried to contact her, they couldn't. And the character committee made a decision on credibility, found that my client's denials, which were adamant, were indeed credible. And I do believe in that situation, some deference ought be paid to the character committee. I'm not suggesting to this court that you must follow somebody's recommendation or anything of that kind. But when it comes to credibility in that scenario, I do believe the best judges of that credibility would be a character committee that's looked the man in the eye, that has seen his manner of responding, that can therefore judge in the flesh the individual's character and credibility. Character and credibility is not something that you can always discern from a cold record. Sometimes you can discern problems with character on a cold record. But when it comes to those intangibles that were discussed in Knight, you're talking about something that's very elusive of precise definition, something that you really need to get a feel for the person. I think my argument would be better made if I could find a witness stand in this courtroom and call my client. We can't do that. We have to decide this based on the record, and because I think credibility is so critical to this process, I believe we should defer to the character committee on that. 5 men, 5 women on the character committee. They gave quite a bit of scrutiny. There were 3 investigators involved, and they all unanimously recommended my client's admission. I think that they were very impressed with the fact that here is a man who had every reason, every excuse throughout his life to fail. And he didn't fail. Now, he didn't emerge from his Pimlico neighborhood unscathed. And yes, Judge Battaglia, sometimes that does leave anger management issues. It does. It does. I mean, I wouldn't deny that. I think what's important, however, is that this man is cognizant of it, is not denying it, is not trying to minimize it. That's critically important. What's also important is to understand that here is an individual who has gone to hell and back and has come out on the other end, and look where we are. We're in the Court of Appeals of Maryland, the state Supreme Court. Could we imagine from back in Pimlico in the late 70s, early 80s, ever getting to this point, ever even getting to college, even getting into college, let alone getting a degree and a law degree? Now, you can go to Harvard, that we know. Harvard would have actually had an application. But the Charlotte School of Law lost its accreditation. Why? Because it only graduated 20% of its student body. Graduated plenty. Only 20% passed the bar. My client failed it 5 times. He couldn't afford a bar review course. Finally, he persuaded Barbary to extend him some credit. Took the course, passed the bar last year, last July, and just finished paying it all off. Your Honor, in closing, I believe compassion is an important element of character, and I would appreciate if this court would exercise it in this case. Thank you.
All right, thank you, Mr. Kramer.